There are 4 calls to this thing. Call 1, did Paul validly serve a summons on, and there are 2 different people or entities. Call 2, does the Superior Court of California in San Diego have personal jurisdiction over those same 2 parties? Call 3 is about venue, properly lying in the Superior Court of California in San Diego. Call 4, is Paul's action properly removable to federal court? So this thing is set in Superior Court in San Diego County, and I don't see an instruction answer according to California law, but
But it's in California. The whole thing's taking place in California. The only relevance of the federal court is the question for is it removable? And so I think we can fairly say that this particular question is the first time the California bar examiners have tested California civil procedure.
okay, so we have 1 plaintiff, 2 parties, reasonably short fact pattern. Paul, a citizen of Mexico, was attending college in San Diego on a student visa.
So Paul from Mexico.
He drove to San Francisco to attend a music festival. While there, he bought and ate a bag of snacks from Valerie, a resident of San Francisco. Valerie is one of the defendants. The snacks had been manufactured in Germany by Meyer Corp, a German company with its sole place of business in Germany. Second defendant, Meyer Corp from Germany.
Okay, so we would have complete diversity of citizenship, assuming that Paul does not have an intent to remain in San Diego. But let's keep moving on at this point.
And our facts that go to him not intending to remain is that he's here only on a student visa, and those are very limited. Okay, the snacks contained a toxic substance and sickened Paul, who incurred medical expenses in the amount of $50,000.
Okay, so we have the injury occurring in San Francisco by a resident of San Francisco and a German corporation. Where the harm occurred is going to be very important to the issue of venue, which I noticed below. And we see that the amount in controversy, if you want to use that term here, is $50,000, and that's going to be below the more than $75,000. So this case won't be removable unless we have more.
Yeah, unless maybe he's going to ask for an injunction. So I'm looking for that as I read on. Paul filed an action pro se against Valerie and Meyer Corp in the Superior Court of California in San Diego. Okay, so this is a tort claim being raised in a San Diego court.
And he certainly can file in San Diego, but let's go to the specific questions as soon as we do the hypo.
In his complaint, he alleged that Valerie and Meyer Corp should have known the snacks were contaminated and demanded $50,000 in compensatory damages. And there's a period there. It doesn't add an injunction or any other kind of relief. It simply says $50,000 in compensatories.
So we already know call for the case won't be removable. The question says discuss, so we would actually go through a subject matter jurisdiction analysis, but we're going to find it not removable to state court. So therefore, this thing takes place exclusively in California.
Paul drove to San Francisco, where he personally handed Valerie a summons and copy of the complaint. He sent a summons and copy of the complaint to Meyer Corp by ordinary mail to the company in Germany.
And that term ordinary should alert you that there's a problem here. But let's look at it. Call 1.
Call 1 says, did Paul validly serve the summons on first Valerie and then Meyer Corp? So what do you do if you haven't studied all those technical rules from California? Because we can sit here and tell you what the technical rules are, but we also ought to talk about how do you handle this if you're not sure when you're sitting on the bar. So Valerie, how do you serve an individual under the California rules of civil procedure? And the answer to that basically is that California prefers personal service. There are ways to substitute service, but the preferred method is personal service. And the the rule says that anyone can effect personal service as long as they're at least 18 years of age and not a party to the action.
And unfortunately, Paul, who served the complaint to Valerie, is the party to the action. And so, therefore, the answer is going to be the service was not effective.
And what about Meyer Corp? It says he sent a summons and copy of the complaint to Meyer Corp by ordinary mail to the company in Germany. So we're talking about service to an organization.
Again, this ordinary mail probably would have alerted people. I mean, we want certified, we want first class, airmail.
So the technical rule is that you can serve an organization by mail as long as you send it by at least first class mail or airmail. And you have to include 2 copies of the complaint, and you have to include other things as well. Whether the CalBar wanted you to go into that level of detail, don't know. I doubt it because there are so many other calls and so many issues to discuss.
So the summons was not validly served on Meyer Corporation either.
So then call 2 asks, does the Superior Court of California in San Diego have personal jurisdiction over each of these parties? And immediately we have a bit of a problem depending on where you studied civil procedure and how your law professor defined personal jurisdiction. Does that include just the test in international shoe, or does it include notifying and serving the party?
Yeah, I think you could probably go either way as long as you explained yourself. But to back up for a second, some of you may be saying, wait a minute, personal jurisdiction? I thought you said that this was California. And we've stated many, many times in our predictions and in our explanations of how California law works, and we've explained that personal jurisdiction is a due process matter and is going to be handled identically in the federal and state system, and every state system is going to have to handle it pretty much the same way. So this personal jurisdiction is identical in state and federal court. It's a big, big issue. Those of you who are going to be practicing here in the state of California, you're still going to have to know how to do a personal jurisdiction analysis. As to Valerie, we'd start out with the traditional basis for jurisdiction. She's a resident of San Francisco, California. She's a resident of the state. So therefore, the state should have personal jurisdiction over her. This issue, was she validly served? If some professors would say, well, that valid service is actually an element of personal jurisdiction. But I think it's a safe, easy way to go. Explain yourself, and I think I would come down and say, yeah, I'm sorry, but San Diego, California would have jurisdiction over Valerie. Valerie's a citizen of California, and San Diego's in California. Meyer Corp is a little bit different, and here's your opportunity to do a minimum contacts analysis international shoe. And you're going to find here that we don't have a lot of contacts, certainly not a lot of facts of contacts. We only have one contact, and therefore you'd have to come all the way down to specific jurisdiction, the nexus between the harm and the contact, and based on specific jurisdiction, the state of California, and San Diego being in the state of California, would have jurisdiction over Meyer Corporation. So I think that's pretty straightforward. And you know what? That was low-hanging fruit. And I think everyone that did a really good personal jurisdiction analysis is going to come out okay in this one.
Call 2 asks about personal jurisdiction. Call 3 asks about venue.
Mm-hmm.
So call 2 is about the power of the court over the person of the defendant. Call 3 asks which is the proper court. Is the Superior Court of California in San Diego the proper court to hear this thing?
So where the defendants reside, where the harm occurs, and basically Valerie resides in San Francisco. It's the county of residence. This thing should be heard in San Francisco, where Valerie lives, and also it's the same place where the harm occurred. So, is venue proper in the Superior Court of California? The answer would be no. And we've already discussed, is Paul's action properly removable? Answer is no. It's removable if it could have originally been heard in the federal court. This one could not have originally been heard in the federal court because there is no subject matter jurisdiction, because the amount in controversy is below the more than $75,000 requirement. Therefore, this case could not be removed to federal court.
And in call 4, assuming you planned your time really well, you could do a full diversity analysis and illustrate that we have a Mexican citizen, we have a citizen of California, and we have a citizen of Germany. And so there is complete diversity. There simply isn't a mounting controversy.
Note that if you took this bar and it was your first response to this particular bar exam, which this was question 1, and you don't think you did very well on it, I wouldn't worry much about it. They tend to be very, very forgiving the first time they test a subject, and this was in fact the first time they tested California civil procedure.
And I really think that the hardest call for most people on this one would have been call 1 if you wanted to be really precisely accurate about it. Calls 2, 3, and 4 you could handle really well just knowing the federal rules, because the venue rules this triggered in California aren't that much different from the federal, as long as you think about counties instead of states. Call 1 was the one where the rules are pretty specific.